Very much for joining us this evening, whether you're attending in person or attending remotely. So thank you all for coming and taking an interest in this subject area. But our subject this evening, as you know, is the Court of Protection and Complex Housing, Hoarding, Possession, Homelessness and Specialist Accommodation. And as I'm sure you know, hoarding is a complex area as regards capacity and best interests and the issues that it throws up in homelessness and housing issues. And in our discussions that we had preceding this evening, it really dawned on me how much this area has really moved along. And for those of us who, first of all, started practicing in housing, we might remember how much of a blunt instrument the law was when you were dealing with a hoarding case, and we didn't have the sort of law that's developed around the Court of Protection now. And we'd be doing things like evicting people and re-granting them the tenancy as the only way to clear their property. And now, of course, with the Court of Protection, we've got much more developed understanding of capacity and also a much more nuanced and individualized approach to helping people to stay in their homes. And that's the bottom line, of course, and what we all want is to find those remedies that will help people to stay in their homes. So without more ado, I will turn to our panel of speakers for this evening, and I'm going to introduce each one as we go along. But briefly, just to tell you the order of proceedings, our first speaker, James, will be talking primarily about capacity. Our second speaker, Amina, will be addressing primarily best interests. And our third speaker, Tim, will be looking at issues and remedies relating to possession and homelessness and the link with the Court of Protection. So first of all, to turn to James, I'm going to introduce you now, James. James is a specialist Court of Protection practitioner who is able to sit as a nominated judge of the Court of Protection. His expertise spans the full range of the court's jurisdiction, including welfare disputes, Section 21A challenges, deprivations of liberty, complex matters before the High Court, and he has particular expertise in cases involving hoarding, forced marriages, challenges to capacity assessments, and contested deputyships. And he has a background in family law and as a tribunal judge in the Health, Education and Social Care Chamber. So, James, I think you're going to introduce the subject a bit first, aren't you? And then you're going to talk about capacity for the next 20 minutes.
Yes, and thank you, Beth, for that introduction. As Bethan says, I think some of the most complex cases that do come for the Court of Protection are the hoarding sort of cases, and that those concerns and the complexities aren't just in respect of legal questions that you have to ask yourself in respect of the questions around capacity, but also the complex question about what practical solutions can you achieve in the Court of Protection, which Amina will touch upon, and also how those can be used in proceedings before the county court, which is part of what Tim is going to bring up a bit later. And that how we can also then use the Court of Protection to encourage local authorities to act proactively to try and come up with solutions to very difficult situations we can find our clients in, and advice we are trying to provide to local authorities when being requested what steps can be taken. But before I wanted to go into that, some of you may have seen end of last week, an article on the BBC about hoarding. This was following a discussion that they had with Clouds End, which most of those who practice in this area will have heard of as an organisation. And it was quite interesting when looking at the statistics they set out, that I think 2 to 5% of the current population in the UK have a disorder. That typically 4 out of 10 hoarders are over the age of 60. That I delved into this a bit more and had a look and found out some more statistics looking at the British Psychological Society, and it says 2 to 6 people, as you can see on the slides, out of 100 are thought to have a problem. It's equally prevalent between men and women, so there's not a high prevalence in either sex. And that what surprised me is that hoarding difficulties typically start in children between the ages of 10 to 13. But I think the questions that behind that are more to do with, we can all see when we were children, we would collect things and how we would have possessions and attachments to objects and items. And you can kind of see from that, and when I talk a bit later, is that is partially where some of this problems as you get older and development and issues with the hoarding develops from. And the hardest distinction in cases is distinguishing between a collector and someone who is hoarding. And that it is surprising when certain cases, having spoken with colleagues and other professionals, is that you have cases when you have people who go, oh, this is a hoarding house. And when you start clearing away the rubbish, you suddenly find there's a very lot of valuable items buried in there that they have carefully looked after and collected along the way. So it's interesting when you look at the subject matter on that level. I've attached a couple of photos, 3 photos off the BBC articles, not cases. There's no issue with me having to get permission in them. But I picked them on the basis that you can see that we are all very used to, I think, the photo on the right and the bottom photo of a hoarding house, when there's just piles of stuff everywhere, no real organisation or anything behind that. And I've seen far worse properties, and I think we've probably all had experience of far worse properties when you have narrow entrances or have properties which have 90% of the house that have no functioning access to any rooms. But the interesting I found with the top left photo was that it was very well organised. There's our further photos of that gentleman's property. He had a fascination with Barbies, and he very much organised them all very well. They're all categorised like that, or they're all on his shelves in their boxes and all very well looked after. And actually, you were able to quite well move around his property. So I think it's just looking at the contrast and what we can see as properties when you see the photos. And one other thing I wanted just to say is, whilst we have all seen properties looking like that, what you can also hoard is animals. So a lot of people, you see the articles on BBC when the RSPCA go in and they found 60 or 70 dogs in properties in squalid conditions. That sometimes is part of a hoarding disorder itself, that you can in fact hoard animals. And I think, having spoken to some of my, I think Tim on the panel, he's experienced cases when people have hundreds of gerbils or hamsters in properties, and that's an underlying hoarding disorder, is why those are actually in the property, not any sort of adverse or criminally neglectful behaviour behind that. So it was just quite an interesting that I looked at when considering this. The question of what we all ask and people is relevant when looking at the questions of capacity and what steps then to take, is why do people hoard? On the slide, I've put the definition from a report from the British Psychological Society in June, I think it was June 2024, middle of last year, when they actually say no other species, however, comes close to human beings and how we mediate our lives through objects. In understanding hoarding, it is useful to keep in mind how people in general interact with things, give them value, use them to achieve things, demonstrate identity through them, and become attached to them. And I think that is all in human nature. We can all relate to that from possessions, that you keep photographs, etc. And it's just when it goes beyond that stage is when it becomes looking, and you see why people start hoarding. And as I set out there, is that the difficulties with hoarding generally present in the older population. In most of my cases, they are older people. And partially that is down to, and when it becomes a problem, it's due to physical illnesses, memory problems, and bereavement. And there's, again, bereavement is that people find that attachment they have, as identified by the British Psychological Society, to the item reminds them of a past loved one, or a husband, or child, or a grandparent, and then they start collecting, and they collect beyond the items they have, and then they can't detach from those items. And that is part of one of the symptoms, is the physiological side of it. But there's also the learning disabilities, when people are unable to continue to categorise or dispose of items, and those relate to people who have learning disabilities or people who have dementia. There is also why people also hoard, it's associated with mental health problems. I think we've all experienced cases, and it is in a lot of capacity assessments, is that they link it to underlying potential severe depression, psychotic disorder such as schizophrenia, or obsessive compulsive disorder. And that was up until very recently one of the main things you'd find that over a number of years ago would be that lot of experts would be saying this is part of an obsessive compulsive disorder, is why this person has all this hoarded items in the property. But what has happened subsequently go on is that there's now the fact that there is a recognised disorder. That disorder I will touch upon later. So there's all these three interrelated things that are going to a question of why someone and why do people hoard, and why it presents quite a complex situation when you are presented with them in court, and which causes the difficulties behind the cases themselves. What would you say, how can you identify if someone has a problem? And three things I would say is that you look out for is the problem of getting rid of possessions, excessive or problematic acquiring of possessions, or restricted use of living space. Those three, there is the interlink of most of them with those issues that people will suffer distress or difficulties. It's not a requirement that you have the distress and the difficulty. You need to look into it a bit deeper. And a prime example is most people in the cases of hoarding will see that when someone is asked to get rid of an item, they can't. They don't necessarily have to physically become upset and distressed in front of you, but they get distressed when they are trying to categorize or identify the things and items they are trying to get rid of. And that they will then deflect or go off the subject or go, look, actually, this is just too much. I can't do so. We'll come back to this later. And that is part of the evidence of the distress and the difficulty someone has in respect of it. Distinguishing between the collecting and hoarding, as I touched upon, is that is difficult and remains difficult in most cases. I've had a case when someone collects bicycles and TVs, and when you were talking at that, you were looking at 100 bicycles, 150 bicycles in the backyard. You'd have TVs and so forth in collected because they had an interest in. They would say, I need 100 bikes because that's how I repair the 5 bikes that I use. And they would go in and clear those 100 bikes. And within a month, he'd be back up to 50 or 60 bikes. And people have said to me, is he a thief? No. And they were quite clear. The police weren't concerned that he was going around robbing people of bikes. He was somehow managing to get, and no one ever got to the bottom of it, where he was finding the bikes, but they kept appearing and they kept coming back. And like he would say, if you're talking to him, he's collecting. But there was the distinct difficulty that he was, when the experts and the professionals got involved, he had the difficulty of he was excessively acquiring. He couldn't realistically see why he needed 100 bikes. Yes, if he had 10 bikes and 5 ones, you could argue repairs, spares make sense. People could see, and you see in London when you walk around, the bikes left on the side of the road, people don't want any more, saying, please help yourself. So you can see a bit of sense to that. But so that was one of the difficulties. The other thing also, and it's something I've recently thought about, or read and understand, is that cultural beliefs and social norms. Because in certain society, in certain cultural understanding, is that having items, having possessions show that you have wealth and standing and so forth. So some people view certain things they collect and have in their possession. And therefore, it's working out what the underlying cause is, when they actually have a problem, and what you can actually do to address those problems. So all as this shows, I think, again, is complex and not straightforward. Commencing proceedings for the court protection, we all should and hopefully be aware of Section 2 and Section 3 of the Mental Capacity Act, and the test that needs to be satisfied for the court to have the jurisdiction. And without such, we don't have the ability to get involved and look at whether there is any best interest decisions that can be made to safeguard and deal with the issues that are presented with. That one of the key issues in the matters that when I'm looking at this is that when you look at it, it's identifying the cause and identifying what is causing the impairment or disturbance of the mind. And that is where it is quite key to ensure that you have the underlying diagnoses of whether, as I've touched upon, the mental health problems. But now what there is that there is the recognised separate disorders under DSM-5 and ICD-11. The hoarding is now recognised as a completely separate disorder. And the definition I've set out on this slide is the ICD-11 definition. And that experts need to consider that, and professionals, when doing the assessments, what the impairment is in relation to. And that the reason I say that it's important partially to understand what the impairment is, not just because of the test under section 2, but also it enables those, when we're looking at how to address the underlying problem, what treatment, supports and guidance what we can obtain from professionals, is that whether you are looking at CBT, whether there's antidepressant medication that can be put in place to address the underlying impairment, or whether support from a specialist agency can put in place. And this goes then to the question of whether that impairment, and goes to the overall question of capacity, whether it is fluctuating capacity or something that is only in a particular context. So it's key when looking at the definition of obtaining the question of what the impairment is or disturbance is to understand, not just purely because the legal test, but to assist us when we're advising, looking for social and support from social services. When looking at questions to the experts, the question is, I would say you need to look out for and make sure that experts actually have considered is the propensity to acquire the large quantity of the items, but also the difficulty in starting. And that the reason I touch upon that is that we need to make sure that difficulty discarding is not something related to a physical issue. The fact that someone is not able to actually physically do it is in separate to the question of the underlying disorder itself. One case I've had is very much that they were saying, look, she's got mental health issues. Clearly that is the reason and cause, and failed to really consider the fact that there was a lot of physical reasons why, in fact, that this person was unable to get rid of the items, and in fact, therefore, it wasn't a hoarding disorder. There was an impairment. The impairment wasn't caused by the mental element of it. It was the fact that they weren't able to actually clear the property themselves because they physically weren't able to. That the person in that case had suffered a stroke and had partially not fully paralyzed on one side, and then having a house that's full of 4 rooms out of 5 full of items. Goes, you now need to clear this. We keep visiting you every week, and you're not making any progress. And the kind of question that is, what progress can you expect this person to make if you don't put the support in? So this is where it's key to work at what the underlying impairment is, and whether there is an impairment at all that is related to the hoarding. The key thing, and I am aware that Amina will touch upon this case also in detail, so I'll touch upon this briefly. This goes to the question under section 3, is what relevant information is being provided to the person and the expert considering when looking at the question of capacity. And the case is the case of AC and GC 2022 EWC CoP 39, sets out a test of 5 things to consider. That case was, and also considered further by Mrs. Justice Tyson, a case in 2023, which endorsed the approach identified by His Honour Judge Burrows in that case is the correct way to be looking at such cases. And also touching just briefly saying is what you also have to look at is not confusing the test with the test of general property and affairs, care and support, which sometimes the experts go in and go, she's got no capacity around the care and support element, when actually confusing that with the question of hoarding, which is the disposing and getting rid of items. So it is making sure when you were looking at the experts don't just go in and say no decision-making ability on any of this. So that's what this case touched upon as well. So I'd encourage everyone to read that as well. Finally, I'm just conscious of time. So what I'm just going to do is, as I set out, is there's over the next couple of slides a number of issues I encounter when advising and going before the courts, is that making sure the assessor is not focused on at the outset what they think is correct. That is something regularly is like, look, clearly this house is a mess, we need to clear this. This person clearly must not have capacity. How could she live in such a property that you can't move around and there's no functioning water, no functioning water, no electricity, the house is going to fall down on top of her. Some of the assessors go in at that, have that in their mind when coming up with the capacity evidence and assessments. So it just reminds you of the case of what Mr. Justice Ryder said in Oldham as NBC. And this goes with the point of unwise decisions. If the fact that someone's living in a house they are just an unwise decision, that and it's difficult. I think reality advising, when you do, whether it is or not, sometimes leaving it to the judge to make the decision is this way. Sometimes it's resolved, may not be the right decision, but it's sometimes very difficult between parties to completely agree. That finally, just setting out the two case examples, saying that most people have complex diagnosis and presentations. Case B was the case about the lady I was just talking about. She had all those as well as potential hoarding. That case went to a capacity hearing. The court decided, in fact, the lady had capacity, and we ended proceedings because we identified the fact that her issue was, and what had caused it long term ago, as I identified this challenging capacity assessments, is life events. We looked at her medical records and clearly she had periods of quite severe depression. At those points in time, that is when her hoarding got bad, then periods settled. And what in that case was how to ensure that she regained the capacity and getting out of a situation, which in that case was the court was being asked to make an order to remove her from the property for a period of time to go to specialist supported accommodation. And whilst at that specialist supported accommodation, she didn't hoard. And that was part of using the evidence to suggest that she had capacity. And it was only because the conditions she lived in was what was causing her to lose her capacity. And that is looking at the situation of how to resolve it. I think Tim will touch upon how we have to be very careful in those situations, not to jeopardise the underlying tenancy. But I will leave Tim to touch upon that because there is all those risks. But it just shows when looking at these cases, it's thinking outside the box, working what support can be put in place, and goes to what is paragraph 4.13 of the code, which is ensuring the person who's being assessed has all opportunities and support in place to be able to make the capacious decisions. And that looks at clearing the property, support in place, identifying someone to help and make sure she's in the right setting when you're asking the questions. So it's a quick summary of the issues that, as we'll have some questions at the end which I can answer, and I'm around afterwards so we can have further discussions, but I'm conscious that I don't want to be speaking for too long, which I could quite easily do. So thank you.
Thank you. Thank you very much, James. Amina, I'm going to introduce you. Amina is going to focus primarily on best interest decisions in the context of hoarding. And introduce Amina. She is a practitioner in the Court of Protection and also in public law peer proceedings, representing parents, children, and local authorities and interveners with experience in cases involving complex non-accidental injuries, sexual abuse, cruelty, and neglect. And as regards her Court of Protection practice, this includes disputes over care planning for adults with disability, capacity issues, and financial deputyship. And Amina worked as a psychiatric nurse before she transferred to a career at the bar, which is a very excellent background to come to this subject with. So thank you very much. Over to you.
Thank you, Bobby. So this section, really, I wanted to try and give people pointers, bring up issues to consider when you are looking at applications, when you're considering care plans in cases. So I'm going to start with London Borough of Croydon and CD. So it's 2019 EWHC, and this was a decision of Mr. Justice CoP. So the local authority had made an application under the inherent jurisdiction, and I've just set out a summary from the case as to the issues CD was facing. And you will see that essentially, due to his alcohol use, his flat was really in a state that he could not live in. The local authority had commissioned a care agency to provide a care package, but they weren't able to access the flat to support with his care needs. Largely, it seems from the case, due to the fear of cross-contamination from the human waste that was about in the flat. So the issue really, to begin with, and picking up from what James has talked about capacity, is are you looking at a case where you have a vulnerable adult, or is P lacking capacity? And in relation to applications under the inherent jurisdiction, Mr. Justice CoP summarised it in 5 points there. The area, I think probably a short summary, but covers the essential points. So inherent jurisdiction, I'm sure as you all know, can be deployed for the protection of vulnerable adults. And that vulnerable adult may or may not be incapacitated within the meaning of the Mental Capacity Act, but they can, of course, be protected. Some of those cases, capacitous individuals may be of unsound mind within the meaning of Article 5. Exercising powers under the inherent jurisdiction, the court is bound by the European Convention, and the case law shows us that only orders that are necessary and proportionate and have proper regard to the personal autonomy of the individual may be made. And fifthly, the court, of course, can take interim protective measures. So that will tell you where you have a vulnerable adult, what can be done. Now, in this case, unsurprisingly, from the short summary I've given at the beginning, Mr. Justice CoP did make a finding that CD was a vulnerable adult. However, in the case, as submissions went on, in fact, the official solicitor was inviting the court to make findings of lack of capacity. There hadn't been a capacity assessment done, and the court was being invited to infer from the evidence before it, within the papers, that CD lacked capacity. And in that situation, as you see from the slide, the court was able to do so. Ideally, you would have a capacity assessment if there was doubt about the person's capacity. However, it may be a situation where if there is an emergency, capacity assessment can't be done. It may be that for whatever reason, no one was able to access the person to carry out such an assessment, and in that situation, if you are of the view when preparing your case, don't forget, of course, that the court can be invited to make findings if there is sufficient evidence to do so. So it's always worth just considering what you have to see whether or not that might be a way forward. So looking at this under the heading of best interests, the case that James had referred to, AC and GC 2022, and this was the Judge Clayton. So AC was 92, and her son, whose age wasn't given, but probably in his 60s or 70s, was originally subject to proceedings. By the time this case came to be, her situation had pretty much been decided. So she was living away from the home, and the idea was that there should be a trial return home. However, GC was still living in the home, and the home still needed to be cleaned so that AC could live there safely. And so, in order for the property to be cleared to a level safe enough for AC to live there, and for a care package to be delivered, it was essential that the items and clutter was removed. And so the parties had agreed that the court should make a declaration that GC lacked capacity to make decisions regarding his own items and belongings, and also lacked capacity to make decisions regarding AC's items and belongings. And that was the first step, of course, to being able to clear the property. So you've seen, I think, this a summary of this before, so I won't spend too long about it. The expert that they had used, Professor Salkovskis, had set out a list of information, relevant information that the expert should consider when looking at the issue of capacity to manage belongings. And I think, as to expand on what James had said, the relevant information that is put to assess their capacity. So I won't read it all out, but you see the volume of belongings and the impact on the use of rooms was one. Safe access and use, creation of hazards, safety of building, and does it compromise the structural integrity, removal of and disposal of hazardous level belongings. And so those are, I would suggest, a very clear and neutral way to put the relevant information to be and so that their capacity can be assessed. And you'll note that they are all issues of practicality, that whatever reason someone has for having a very large number of belongings in there, it is really about practicality and can that person live safely in their property. So in having dealt with the capacity, in this particular case, the proposal that AC should have a trial at home and a package of care obviously was assisted by the findings in relation to GC's capacity. He had agreed the appointment of a deputy who would take over the decision making as to the management of items in the home. So that meant that neither AC nor GC made those overall decisions. He was also willing to engage in therapy, although if you read the case, you'll see that there was some discussion about how useful the therapy he was being offered was, but the idea was that because he was willing to engage, that gave the court some confidence that this package would work. And so those matters all together led the court to consider that the proposed package of care had an improved chance of succeeding, and therefore approved a trial return home. And so if you're looking at a care plan for a trial return home or a return home, what you want to ensure is that there are measures in place that the hoarding simply doesn't restart and the whole cycle comes back again, and then there is further intervention down the line. So the appointment of a deputy in that situation meant that that decision was taken away from GC and AC, and meant that the clinic would be controlled. Another slightly different concept for a care plan. This is the case of a local authority in X, and that's the case Mrs. Justice type DBE. So X was a woman who was diagnosed with severe obsessive compulsive disorder and hoarding disorder. It was a cluttered flat. She had been there for 27 years. There had been a long history of attempts to declutter the flat, to make repairs, and that was before the proceedings had started. The proceedings themselves, there were 2 years worth of attempted interventions up until the point where the local authority took the view that it was not going to be possible to clear the flat with X in place, and proposed a plan that she be removed and placed in supported living in the period of the clearance and the works. And the plan itself also provided for a multidisciplinary staged approach with the aim of seeking X's cooperation, specialist support, and in the event of non-cooperation, the court went so far as to approve a plan for restraint to move X from her home. The multidisciplinary approach, obviously, when you're looking at your own cases, is an important element. who those professionals are may vary from case to case. Each person, of course, is an individual, but bodies such as the fire service will assist. If you have a case of animal hoarding, the RSPCA have been involved. You may have a psychologist, you may have a professional organizer. The idea is to deal not only with the clutter, but also to support P while this process is being carried out. And that support, of course, is essential to not only reduce stress for P, but also to start work in terms of perhaps dealing with the underlying issues that P has. Just some points to consider in care planning. You've been taken through the diagnosis. And the next few points I took from the document Psychological Perspective on Hoarding, the Good Practice Guidelines. That's available free online. You can just search that. It's a free PDF to download. It's a very helpful document if you want to just get a primer on hoarding. And so as we see, people who hoard are more likely to have experienced a traumatic event than those simply with OCD alone. A higher self-reported rate of traumatic events. Of course, hoarding has been traditionally associated with obsessive compulsive disorder, as James outlined for us, but of course it can occur without that. And P may also be suffering from depression and anxiety, PTSD, ADHD, that all of those are overrepresented in people who have a hoarding disorder. The reports said there's limited research on hoarding among people with intellectual disabilities, so that's not, doesn't seem to be a relevant co-factor, except the one place that it does seem to coincide is in Prader-Willi syndrome. For essentially, one of the features of that syndrome is that not only have no limit on their hunger cues, but also can tend to hoard food. And so that is a very separate issue and doesn't tend to lead to the kind of hoarding that we are looking at of possessions. So any intervention ideally done in cooperation if possible. Forced cleaning or blitz cleans can cause severe distress. Blitz cleans are something obviously can be part of a care plan, but ideally with the knowledge and cooperation of P as part of a more holistic package. If it's simply done essentially behind P's back, it can make things much worse. The severe distress, not only to P, but also once P returns home, it does nothing to resolve the issues which caused to hoard. So in summary, it said a diagnosis is required to ensure that care planning is tailored to P's needs. And that's really about the underlying conditions, the approach that may work for someone who has obsessive compulsive disorder is not necessarily going to work for someone who has ADHD. So it is a good idea to know exactly what these needs and conditions are, so that the work that is put in is useful and supportive to them. Multidisciplinary approach, and care plans, when you're considering them, when you're going through them, they need to be detailed and practical, with very clear requirements for not only the workers but also for P. And if this is a case in which an application to remove P from their home is contemplated, you need to have clearly evidenced failures of interventions where P remains in the home before any more restrictive measures are sought. It can be tempting to think, well, we can solve this all by moving P out to a care home, get everything cleared out and move them back again. But there are less restrictive ways to deal with these issues, and there needs to be clear evidence that that will not work. So thank you very much.
Thank you very much, Amina. And just to mention, if anyone in the room isn't someone who practices in the Court of Protection, when we say P, we mean the person who's subject to the proceedings in the Court of Protection. Not every case, of course, makes it to the Court of Protection, and quite often as housing practitioners, we're trying to get the case into the Court of Protection so that our client might become a P in the Court of Protection, where they will have access to all these wonderful individualized, tailored remedies. But sometimes that's not achievable. But I'm sure it's something that you, Tim, have a lot of experience of doing, probably very successfully. So
going from P, is that
exactly that. I'm going to be Tim Baldwin, who is now going to speak about issues relating to possession and homelessness and the Court of Protection. And to introduce Tim, Tim is ranked for his key practice areas and was nominated for Court of Protection Junior of the Year at the Legal 500 Bar Awards last year. Tim is co-convener of the Court of Protection and Mental Health team at Garden Court Chambers and has considerable experience in proceedings in health and welfare decisions, accommodation and deprivation of liberty safeguards. Recent cases have concerned disputes over residence, contact care and DOLS authorizations. He's also co-chair of the Housing Law Practitioners Association and a member of the Legal Aid Advisory Panel, and he is on the Access Social Care Advisory Panel. Tim, over to you. Thank you very much.
Okay, thank you. It's been very interesting hearing about hoarding cases. When I first started out in housing work involving hoarding cases, my first case involved the obsessive hoarding of guinea pigs. And it was only discovered when the guinea pigs escaped and started chewing through the electrics in the building that the blackouts led to an investigation and a claim for possession. Then the diagnosis was one of what was called Diogenes syndrome. Diogenes, an ancient Greek philosopher who lived in squalor, preferred isolation from humans, and preferred the company of dogs. Can't see anything wrong with that from my own personal perspective. But what I'm going to talk about tonight is a bit more broader than that, looking at the Court of Protection and how it can provide an additional remedy, particularly when you're faced with possession proceedings, and the difficulty also associated with homelessness and maintaining somebody in their home. So what I'm trying to do in this first slide is try and identify the real importance of the Court of Protection in complex housing cases. Often the very first circumstance when you start thinking about the Court of Protection in a housing case is when you're faced with a possession claim. You turn up, you might be a duty provider, you might have some referral, but the position you're in is that you're subjected to a client who is subjected to the powers of the county court. And in reality, the powers of the county court are limited in terms of what remedy it can provide to a defendant tenant when they lack capacity, when possession proceedings are started. Because really, what you have in a county court are either mandatory or discretionary grounds of possession, and the county court can only dismiss, allow, or suspend possession orders in specific circumstances when it meets trial. It can, of course, always adjourn and stay proceedings pending other types of proceedings. And even this is even a case in terms of the nature of the orders it can make, even when a tenant is disabled or lacking capacity. The Civil Procedure Rule Part 21 only provides for a litigation friend when somebody lacks capacity to litigate. So the litigation friend, their role is in respect of how the possession proceedings are managed, not how complex issues in respect of mental incapacity and other sorts of decisions that person can or cannot make. So at that point, you may need to consider when you have a client who lacks capacity to litigate, whether there are other areas that that client cannot make decisions in. We always have to remember that mental incapacity itself is no absolute defence to possession proceedings. Even when you use tools in the Equality Act, the lack of mental capacity can be an issue, but it may not give you any sort of defence. It may be that the court decides that, well, it may be discriminatory, or you engage the Equality Act, but the measures taken are still proportionate. And also a lack of mental capacity can legally prevent a tenant or a homeless person making applications for homelessness assistance or allocation of accommodation. And there's always a situation where you could, in theory, have a tenant who can have capacity to litigate, but not have capacity to make other decisions, such as where to live, where to receive care, or manage their rent. Unusual, but you can get either a combination of a lack of litigation capacity or a lack of ability to make decisions in respect of other decisions. An application to the Court of Protection by those representing the tenant or the landlord in these possession proceedings may be required. All you need, the threshold, is a reason to believe the tenant may lack capacity to make those relevant decisions, in addition to a lack of capacity to litigate. But I warn you, you can find individuals who lack capacity to litigate, who don't lack capacity to litigate, sorry, but lack capacity to make these other relevant decisions. You have to be very nuanced and careful about how you approach it. And if that happens, it may require the Court of Protection to make best interest decisions and to make certain determinations that may be adverse to what the tenant wants. It may say, well, we think it's in your best interest to go into specialist accommodation, to give up this tenancy. It's not in your best interest. But at least it gives you an additional remedy, an additional threshold that the county court cannot give you. It can also give you a bespoke package of care, which allows the tenant to remain within their tenancy and persuade the judge in the county court to suspend a possession order. So it can give you an additional remedy to help your client defend their possession claim, or a route to more appropriate alternative forms of accommodation, either within the mainstream or bespoke. What is often forgotten by local authority officers is that as professionals, they must have regard to the Code of Practice under the Mental Capacity Act, Section 42, and in particular section 42(4)(c). That raises capacity issues and that raises safeguarding issues. So on those circumstances, then the local authority, if they're looking to secure possession, should take proactive steps. And particularly within the pre-action protocol, it says, and I've underlined it here, if the landlord is aware that the tenant is particularly vulnerable, so it's not a test of capacity, it's a test of vulnerability, the landlord should consider at an early stage whether or not the tenant has the mental capacity to defend the possession proceedings and the extent to which CPR 21 applies. The court itself also has, under the equal treatment bench book, to be aware and be proactive in respect of if someone appears in front of them and they lack capacity. And also whether or not issues arise under the Equality Act, and in the case of a local authority landlord, whether or not there is a need for a community care assessment in accordance with the Care Act. It makes a distinction here between a local authority landlord and another residential social landlord. But in my submission, in this court of peers, that if you have a residential social landlord and this issue arises, they should be making a referral of some kind to the local authority. I accept that a housing association doesn't have social services functions, but it should think in the context and the spirit of the pre-action protocol, if these types of things arise, they should be making a referral to social services. But if you do have a litigation friend involved, they should be proactive there. You just cannot sit back and hope it will happen. It's different with private landlords, but a gateway through the use of the Equality Act may enable the accessing of a litigation friend and also the court of protection, because the county court can always adjourn. I've said it's on the Judge Luber once, you have to adjourn because the court of protection is a high court jurisdiction and you are merely a puny judge. You didn't quite get the puny judge. Anyway, how the Court of Protection might provide a remedy. What are applications to the Court of Protection? What can they achieve? Why is having a litigation friend not enough? As I said, a litigation friend only has a role in making decisions about the litigation. It doesn't have a role in how other decision making can occur. So possession proceedings, I see Alex right in front of me smiling away as he usually does. And typical things are paying rent. You can get mandatory or discretionary grounds depending on the type of tenancy. You might need the intervention of the Court of Protection to appoint a deputy or take over the management of the payment of somebody's rent if they're not able to do it, if they don't open their mail, if they lack capacity to manage their affairs. Welfare benefits, that can also be similarly linked to that. You have appointees with the work and pensions, so that's a special role that someone can have just to manage benefits, but often that's something that is often required. You might need somebody to manage somebody's finances, take that over. Antisocial behaviour is often linked into the hoarding is often a subset of antisocial behaviour, and also other forms of antisocial behaviour, yelling at your neighbours. Again, you have mandatory or discretionary grounds. Why does that arise? Does that person lack capacity such that they cannot manage their tenancy in a way that complies with its terms? Do you need the intervention of the Court of Protection to make orders in terms of removing them, helping them with a care package to help them manage and maintain their tenancy? These are all things that the Court of Protection, if you have somebody who lacks capacity to make decisions in particular domains, in addition to their capacity to litigate, can provide or assist with a remedy, or at least try and persuade a county court judge to maybe suspend a possession order if there's a care package in place, and sometimes you can persuade a judge not to make a possession order in such circumstances. Succession cases, what happens if somebody succeeds to a tenancy and lacks capacity? Can they enter into that tenancy arrangement? Injunctions or enforcement, alternative accommodation. That is all something that the Court of Protection, when they are properly engaged and enabling somebody who lacks capacity to make decisions, provide them with a remedy, provide them with an extra route that they will not get merely by going through the county court proceedings. Homelessness and housing, complex, about maintaining existing tenancy. And the problem is that if you lack capacity to enter into a tenancy agreement, you cannot apply in law under Part 6 or Part 7 of the Housing Act yourself. And the key thing is that under Section 16 and 17 of the Mental Capacity Act, the Court of Protection has powers, if somebody lacks capacity, to make decisions in their best interest as to where to live. That's specifically stated within the statute. So how really can the Court of Protection help you and your client? Well, if they lack capacity, it can help in various domains, such as residence, care, things like that. It can help a lot. And often you'll find that you have an interaction with the Care Act or continuing healthcare provision in this context. And often you require orders for sharing information between the county court and the Court of Protection. The Court of Protection has very specific rules on what and who you can disclose stuff to. So you'd have, if you're in the Court of Protection, you'll have to get an order to allow that under limited circumstances to disclose that evidence to the county court. So as I said, the jurisdiction and powers of the county court. Section 48 of the Act is the threshold for the jurisdiction and the power to make interim orders. All the evidence is that you have to have some reason to believe that someone lacks capacity to make a particular decision. And you just need some evidence that the client may lack capacity to make a decision on a particular issue. You don't need conclusive evidence. You don't need to prove it on a balance of probabilities to enter into Court of Protection proceedings. Some reason to believe. So the issues that come up are where to live, receive care, entering, terminating tenancies, finances, and also contact. Court of Protection can make injunctions to prevent other people, other nefarious individuals, who are interfering with that incapacitated person's welfare in accommodation, to prevent them from doing that. So what I've set out here is the basic powers in the statute. You can make an application for a personal welfare decision under Section 47. You can use the inherent jurisdiction powers of the High Court granted to the Court of Protection to get injunctions. Section 15, power to make declarations in respect of capacity and lawfulness of an act. Section 16 allows for the appointment of personal welfare deputies or property and affairs deputies, and also the power of the court to make specific orders. Section 17 and 16, personal welfare decisions, which can include where someone should live, and can also deal with issues of care and contact that that person may require but can't make decisions about. 18 and 16 is about properties and affairs. That can be entering into tenancies and managing money. 7 talks about payments of goods and services. We'll see that deals with benefits. And Section 20, you might already have somebody who has lasting power of attorney. That person has rights to effectively exercise powers in respect of Anyway, also the court can appoint deputies for financial matters, either they're financial deputies or panel deputies. So if someone can't pay their rent, doesn't apply for benefits, then the court can appoint somebody, maybe a family member or a panel deputy that is a group of individuals that are effectively on a panel and the court can appoint them. As you're aware, sort of James and Amina have gone through the Mental Capacity Act, Section 1, principles underlying the Act, always important to start with that. Section 2, capacity, how is it defined? Section 3, inability to make decisions. And if someone is deemed to lack capacity, best interest, the court has the power to make decisions in their best interest on their behalf. And the key issue to always remember in capacity determinations is it's to make specific decisions at a particular time on a particular issue. And even so, there's a functional test. Can somebody make a decision in respect of where to live? Can somebody make a decision in respect of to pay rent? Can somebody make a decision in respect of receipt of care? If they can't, what is the reason for that? And that reason has to be caused by an impairment or disturbance in the mind or brain. If you make the application to court protection, you don't have to have a confirmed diagnosis to start with. You just need some evidence, some reason to believe that that person may have an impairment or disturbance of the mind or brain. It could just be a GP letter. It doesn't have to be determinative in order to make the application. So often the domains of capacity that are relevant to possession proceedings are making decisions as to residence, that is where to live, making decisions as to care. Often that person may need a care package to support them in a particular type of accommodation or their tenancy, and also entering into and ending tenancies. A person may have entered into a tenancy but lose capacity while they're a tenant, and then they can't end it if they're deemed to lack capacity to end it. And often these things are all combined where you need a whole package to also manage their finances, to pay their rent, even in specialist forms of supported living. These are all decisions that can be made by the Court of Protection in somebody's best interest if they lack capacity. There is also the residual inherent jurisdiction if somebody has capacity, but they are particularly vulnerable, for example, to financial exploitation. So even if you are clobbered on the capacity issue, if you have a particularly vulnerable person, you can still, in theory, if that person, for example, is at risk of exploitation by others or is very vulnerable, then they can use inherent jurisdiction. Beth has given me the yellow card. So this just summarizes, in essence, the best interest issue. And there's other sources in addition to the statute. You'll get a copy of this in respect of other relevant bits of the code of practice and other things to consider. In addition, one of the issues that often can happen is, well, what happens about welfare benefit decisions? This is dealt with generally under Section 7 of the Act and appointees. And one of the classic cases that was involved in this is called Whitehaven District Council EM, where the tribunal held that a purported tenancy agreement was a nullity as the occupant was so severely disabled as not to be capable of indicating any assent, that is, agreeing to the tenancy, but it went on to hold that she was entitled to housing benefit because the supply of the accommodation had been necessary. So that's your first point in dealing with tenancy issues. This is generally what can happen in terms of Part 21 of the CPR. But one of the key things that you may encounter is a problem with an individual who does not have such a debilitating condition that they need specialist accommodation, either in supported living or in a residential care home. The problem that you may encounter is if that person has to be rehoused, but they cannot apply as homeless And that is set out for the reasoning in the case of Ferdus Begum that's identified here. Because it was determined effectively that it still remained good law, because the view was that the person lacked capacity to enter into a tenancy agreement. So how on earth could they make an application for homelessness assistance? And that was affirmed by the case of WB versus W District Council here. But they did identify that if either you have a deputy appointed by the Court of Protection or an individual who is nominated by the Court of Protection, they can make that application on your behalf. That is how you effectively get around it. And I've basically tried to set it out here. So finally, succession. One of the big things these days in terms of social tenancies is a parent dies or a family member dies and they leave somebody in the property. There's a right to succeed often to that property. Now, it's been determined that minors can succeed to a tenancy. I've described the case of Kingston on Thames, our LBC versus Prince, a rather old case. And in such circumstances, the property was held on trust for the child until they reached the age of majority. So in theory, any child can succeed to a tenancy, even if they're a minor child, if their parent dies and there's a right of succession. And there's another case called Newham LBC versus RIA. So what happens if you've got an adult who is, say, the child of a parent and their parent dies? They may have been heavily dependent on that parent. They may be learning disabled. They may lack capacity to enter into a tenancy agreement, manage their residence and care. They lack legal capacity to enter into a tenancy. Can they succeed to tenancy? Well, there's been no case on it, but there's no reason in principle why they should not, because there's no reason why the local authority cannot hold it on trust for them as an incapacitated person. If you can do it for a minor, then there's no reason you can't do it for an adult. So I'm going to stop there because Bethan's about to give me the red card.
Thank you, Tim. Very much for all our speakers. And we now have 10 minutes for any questions or comments from the floor. Yes, up. Okay.
So, I work for the council, but I mostly deal with tenants, so I'm not familiar with the Court of Protection. So sometimes we've got cases where in the past we've asked to apply for injunctions against a hoarder, etc. I was wondering, in terms of the Court of Protection, if there was like an urgent issue where we felt the tenant's life was in danger in terms of the overcrowding or how many items they have in the property, how quick are the Court of Protection in making orders, or if you need to make an urgent order?
There's a route. If you look on the Court of Protection website, there's a whole series of steps that you can take to get urgent applications before the court. There are urgent out of hours applications, and there are urgent on notice applications. It depends on the urgency that you can do it. You can get an urgent interim application and a return date. It's unlikely, unless it's really life-threatening, the court will make an interim order requiring removal. Those situations, in my experience, have only happened when there's an imminent risk to the occupant. Sometimes the classic ones, if they're at risk of sexual abuse or exploitation by a family member, if someone has moved back into the family home coming out of prison, then that can happen then. But it can be very quick, but it depends on the precise nature of the urgency. At the court, if you are going to move somebody out of accommodation, are likely to require there to be an attended hearing, and you'll need pretty compelling evidence, both in terms of one, capacity, and two, best interest to get an urgent move.
I agree with Tim, you can get quick hearings. I think the reality is hoarding cases I've done, I've been in a case when basically a block of flats has been emptied because to all the other tenants, risk of life. To the person still in the property, risk of life. But the proceedings took 3 or 4 months before anything was actually done because there were structural surveys saying the person was in the ground floor flat and basically undermined most of the flat because he pulled things out, tried to fix things himself. The floor above him could fall down, so it was an imminent risk of life. And I think there was a concern that the court, the issue in that part of the case is where did this person need to go to safeguard the person, and there was also then a risk that if this person went somewhere, they go wandering because they think they're in different. You couldn't just move them to Birmingham, for example, because they would be at risk by going to Birmingham. So it's a bit of a balance, but I think the local authority also took the view, I think, that if subsequently the building did fall down, at least you say, look, we're in court. We can't do anything. Court has told us we're not. I'm not saying that's what local authority should be doing, saying that protects them on an insurance level, but I think there was that level of reassurance that look, they were trying to come up with a package. And the other point is he'd been in that house structurally unsound for probably a period of like 12 months beforehand. So if you would find that any judge would probably go, where's the urgency? I know you said it's condemned and it's going to fall down at any point, but it hasn't fallen down for the last 12 months. So what happens if we leave it for the next few weeks? There's a quick way to do it.
And also it may be a situation where if it is really severe, that there may be interventions under the Mental Health Act. So, you know, that sometimes what people can fail to consider is there are a range of options. It's not just a good protection. It may be that there's a requirement that this person's got a mental disorder that requires either admission under Section 2 of the Act and Section 3. And even if they are admitted under Section 2, within that process, an examination can occur as to whether they have mental capacity issues that then, so even if the section doesn't hold up, as it were, for want of a better phrase, I'm trespassing on Amina's past practice, but there can be a reconsideration of whether a lesser restrictive remedy is required. But
sometimes our clients do yearly gas inspections or electrical inspections, and the contractor goes and then they tell us, client department, oh look, it's hoarded. So they don't necessarily want to move the person, they want permission to remove their items so that contents going safely, and then get rid of any rubbish or hoarding. If that can be done like an urgent basis to go in and remove that so they can do the inspection.
But I think the other thing is you need to look at whether there are other avenues to the fire service, and so because they come in and they look at fire risk. And I think the key thing to persuade in any application that it's so urgent is the evidence. Like you could have a case, oh, it's going to burn down, so who's told you that? And like you see applications, we advise, and we see applications come to us saying, what steps could we take? And you're like, you need to get more evidence, a bit more here. Like, yes, we can see you've probably got this going to burn down, the gas has been turned off, but it's difficult in that sense.
I mean, because the Court of Protection does also within the statutory framework oblige everyone to consider the least restrictive options, you know, that you are invading someone's home, you are all of a sudden you're saying it's going to burn down or something's going to collapse, but it hasn't done that previously. So it's a balancing exercise, but in real urgency, you can get the Court of Protection Act really quickly. It's then really the difficulty is often then how you are able to enforce the Court of Protection order, because it's very different from a Mental Health Act case. You know, the Section 136, the police powers under that Act, you may have to get a specific form of order, say to allow the police to enter and remove somebody, or an ambulance to move that person. It's not always straightforward.
Thank you. Okay, thank you for those very full answers.
I think we've got a question.
Right, so yes, I'm going to take, there are a few that have come in online. They're mostly to do with tenancies. So rather than going to those straight away, are there any questions which are not specifically housing related? And then I'll go back to the housing related ones. Yes?
Hi, just a question about capacity. How does the corporate protection deal with someone where capacity might arguably fluctuate? So someone who maybe has a mental health issue where when it's a good day, they're able to manage things, but they have periods where they manage nothing.
Amina, do you want to answer that?
Yeah, well, I mean, fluctuating capacity is obviously recognised by the corporate protection, and if you have your capacity assessment and whoever the assessor is has said that the person's capacity is fluctuating, orders can be made so that for example, if it's a local authority dealing with that if they're in a period where they have capacity, then they can make decisions. If it's clear that they're in a period where they're lacking capacity, the Court of Protection can approve whatever decision it is to be made on their behalf. And so that leaves it to usually the professional dealing with that person who has knowledge of them, who can tell when it is they're in a state where they have capacity and when they don't. It makes it harder to draft those orders, and you have to think very carefully about how the terms are set out, so that you don't leave the person in a position where they have capacity, but somebody thinks, oh, it's all right, I'll just do this because it's easier. It takes a bit more thought on how to do it, but it's very possible.
And Amina, can I just follow up on that with you on this question, which is linked, which has come in remotely? When making an application to the Court of Protection to stop possession proceedings, to move P out of their home temporarily to declutter and clean the property, how old should the capacity assessments be? Comment on that.
Well, it needs to be pretty recent. I suppose it's how cogent it is as well is also an issue. So if, for example, you have a psychologist or a psychiatrist who has previously met an assessment P a year ago, and you have a very robust and full report, then yes, a year-old report is fine. If you have, for example, 6 months ago, the GP popped in and then the social worker emailed the GP and they sent back a 3-line email saying, I don't think this person has capacity, that's not really going to cut it. But if you're in a situation where you're looking at a more urgent application, then that's part of your evidence, and you will be intending to get a fuller and more robust assessment. So you don't want a very old assessment, obviously, but if you...
And when you say very old, I mean, do you think 6 months? Getting past 6 months?
Yes.
Seems quite old.
I would have thought 6 months to a year, depending. I mean, it also depends, of course, on what the impairment is. If the person has an impairment that is either from birth or they have had for a long time, and it is either deteriorating or not subject to change, and you have evidence that impairment that person is not likely to regain capacity, or that their capacity is not fluctuating, then I think you could probably go back a year or so and you'd be all right. But you would, in that situation, you would be expecting during the course of your proceedings to update that capacity evidence. But I think that would be enough to start it off if you were in a position where you wanted to move quickly.
Okay.
I think it also depends on what I might call the level of invasion. Are you going to restrain somebody? Are you going to require the court to authorise restraint? It really depends, really, I think, as Amina said, it's a little bit like how long is a piece of string? Because capacity is not it's a legal definition. People look at the reports and think that's defined. In the end, it's still a legal definition for the judge, and the judge will be looking at things like, you know, if you're going into somebody's home to remove them, the likelihood is you're going to have to restrain them. How, who and what, who's going to restrain them and how is it going to be done? And also in respect of this idea of fluctuating capacity, that's based on the fact you can anticipate when somebody's going to lose capacity. But there's another concept called longitudinal capacity, where there's what's called a long-running a macro decision, where you can't identify when somebody is going to, you cannot anticipate when somebody's going to lose their capacity.
And I think if you look at the case, there's a case, recent case, citation escapes me from the Justice CoP, when he's gone through a case, a long-running case, when the case of the person has fluctuated, he started with fluctuating and then is gripped and changed. There was a recent decision, and I think the case I had when we had this question, the judge decided, did my client have capacity, or was it a question of longitudinal or fluctuating? The expert said, look, yes, she's had periods of depression in the past, but I can't categorically say that it's going to vary enough that actually, yes, we can say it's fluctuating. It's going to be very time and specific. And some of the cases when they have been able, the courts have intervened and made the anticipatory declarations going, if these things are satisfied, or a professional looking at this person. So for example, having got up to 1,000 bicycles, that's a sign that they've lost capacity. It's very hard, and the courts are very cautious about making it, because it's the invasion it gives to a professional to be able to go in and say, I'm going to clear this down because I've got enough objective. And we said to the expert in my cases, could you give us a list of things that you as a layperson could go tick, 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 yes, no capacity now? Or do you just have to come back to court? And reality, the expert said, well, do you just have to come back? So I think that's why the courts finding the most difficult cases and actually giving their statement.
Because you have to have a workable care plan for people.
Okay, so I just want to mention, thank you very much, Sarah Jane Williams, who on that subject, you said anticipatory declarations, James, a case which is useful, Leicestershire County Council against P 2024, CoP 53. We'll tell you all about these principles that have just been discussed, fluctuating capacity and the options available to the courts in terms of anticipatory declarations. So just a couple of one-line answers now, given that we've gone over our time. Okay, so I'm going to do the first one. Is there a case or guidance that assists with undertaking the capacity assessment around managing a tenancy? There is a case from 2014 called QR against Islington, which is to do with entering a tenancy actually for supported living, but it's used generally in relation to capacity relating to entering into a tenancy. There is also guidance kicking about, and I know that 39 Essex Street have produced guidance on assessing capacity in a variety of areas. I'm pretty sure they will have their guidance online relating to entering into a tenancy, which includes the understanding necessary to be able to manage it, even though you may require assistance to manage the tenancy, you still have capacity to hold that tenancy. So a quick question now is, I work for, so if this could be answered in one line, I work for a registered landlord. If the landlord had concerns about capacity, but the local authority were of the opinion that the tenant had capacity, but had not conducted an assessment, could the landlord apply to the Court of Protection? Would the Court of Protection entertain such an application, given the local authority's opinion? Anybody want to just give a quick thought? It won't be a comprehensive answer.
I mean, I think it depends what medical evidence you would have to support an application so that the landlord can demonstrate that they had reason to believe, because in this type of case, you make an application, there's a permission threshold anyway. So in theory, yes, but it depends what you base your capacity assertion on. You cannot just say, I think so. Somebody else say, I don't think so. There has to be like a GP letter or so even a social worker visit, something.
Thank you. And then finally, and this is very difficult to answer in one line, can the Court of Protection be used to thwart the eviction of P, that's the person who's subject to the proceedings in the Court of Protection, in an otherwise clearly made out case for eviction in the county court? Well, I think it depends on what sort of tenancy there is, basically.
And I would say no,
I think
on the
that is-
basis that Court Protection can't prevent an eviction as far as happening, as far as I'm concerned.
We cannot, I mean, because the county court and the Court of Protection are completely separate jurisdictions. It's really how they interact, because the Court of Protection powers are limited under section 1615. Those are to make orders and declarations, but the Court of Protection cannot, that's the A and NCC case, the Supreme Court case. The Court of Protection cannot compel public bodies to act in a particular way. So if it's a local authority wanting an eviction, Court of Protection cannot compel them to stop, and likewise it cannot compel the county court to stop if the county court is satisfied that the grounds for possession are made out.
And I think this goes just, I know it's one word answer, is that there's a recent case where it went in front of SwiftJ, basically said the Equality Act is a question that has to be answered with, but doesn't prevent the eviction, which would equally apply to the Court of Protection. Said, look, this person's got no capacity, that doesn't prevent the eviction. So it's the same sort of principle, I would say.
Yeah, I mean, because there the argument was, should the residential social landlord have made an application to the Court of Protection in a proportionality argument and decay? My thoughts on that was, well, one, the residential social landlord doesn't have the same powers as a local authority to do capacity assessments, so you're asking them to do something they can't do. And also the court has made a determination that such an application is effectively doomed.
Yes, that was fine.
Okay, and just, I don't know if you've got the name of that case, that's a recent case by, decided by Mr. Justice Swift.
What?
Which was not massively helpful, for.
It's
cases-
on, so the simple thing is, local government lawyer website has this case on it as hoarding tenant fails in High Court challenge to grant possession order in favour of social landlord. That's the article on it, which we have the case in it.
Right, I think it's Richmond.
It's
Something like that.
theme versus Richmond.
Housing partnership.
Thank you. 2025, obviously, SwiftJ. If you're trying to get your case out of into the Court of Protection, to run parallel in the Court of Protection with the possession proceedings, that is a case to look at. Your case may or may not be similar or similar enough to be affected by the ruling in that particular case, but it's certainly one to know about. Okay, so that's everything. Thank you so much. Thank you to everybody in person and online, and thank you very much to our panelists for all your work and for your very interesting and insightful talks. And if you've enjoyed this event, then please visit our YouTube channel, where we have videos from past events on a whole variety of topics that may be of interest to you. And yeah, that's it.